Hi, everybody. Welcome to the Insurance Journal's Academy of Insurance's weekly webinar series. I'm your host, George, and for today's webinar, Certificates of Insurance, the good, the bad.
From the standpoint of looking at certificates of insurance, this is a topic that a number of us have shared information on for a number of years, and it is one of those topics where we always get great involvement. If you have a question during the presentation, just put it in the chat box, and I'll be able to respond to you during the presentation. So don't be bashful if you have a question. I look at certificates as kind of one of those things that were at one time was pretty much just an innocuous piece of paper, right? It was just another insurance form. Who cared? It didn't matter. Now, what's happened now is it's kind of morphed, if you will. It's into a potential minefield of issues, of challenges, of redos, of contractual innuendo, and more. It was funny. I was just working with a client just yesterday, in all sincerity, doing an E&O audit, and they had just issued about 20 or 24 certificates of insurance on a renewal policy that was due to renew, I think it was the 28th or the 29th of this month of August, so like 4 or 5 days from now. And the individual who had issued these certificates and sent them out on behalf of the insured said, Casey, I just got news today that our insured said, hey, nothing personal, but I've chosen to move my coverage over to carrier B. They got all my other stuff and I could save some money and blah, blah, blah. And the individual at the agency said, Casey, what do you think I should do about those certificates that I've already issued and sent out to people? And, you know, being a typical consultant, I didn't want to give her a firm answer because come on, that's not what consultants do. We say, well, I don't know. No, what I said to her is, what do you think you should do? And I sincerely said that to her, and I meant it, but I was pretty sure she and I both knew the right answer, at least from my perspective. And she goes, I think I should send out notices to those people that that certificate has been rescinded. And I said, yeah, I think you really do. I think you've got to. Extra work, yes. Extra work without payment, yes. But that's how certificates have morphed. So, right? What do we think we know? And what do we know in most jurisdictions? And I'm going to say that because part of what we look at today in some ways are really potential areas from outlying states or states that kind of take a little bit of a different look at the certificate of insurance as opposed to the majority of states. Now, we got 50 of them, so you can do the math and figure out, well, majority is only 26. I don't know what the number is. I'm not going to tell you I know the number, and I'm certainly not going to make up a number. But we know that for the most part, they're issued for informational purposes only, right? You've heard it for years. These are a snapshot in time. That's all this really is, Mr. Insured, is a snapshot in time. It was good when I issued it. If it changes tomorrow, all bets are off. We know that for the most part, they have no weight when it comes to the application of coverage. And this is something that we've been taught for years. I've been teaching for years myself, right? Now, just how true is it? Well, it is again true in the majority of states, but we're going to take a look as we go through, and it'll be a quick look, okay? I'm going to look at 3 specific court cases for you that kind of address to a different degree that, you know what, that certificate that was issued, it's more than just for informational purposes. In fact, we as the court are going to say, hey, this is how we view that piece of paper, if you will, that was issued on behalf of the client. And here's what we're going to say it means. Now, again, these are outliers, but they are significant, A, if you're in that state, or if you have an insured in that state, or also from the standpoint of, as we know, can occur with some frequency. Courts look at what other courts have said and then decide, that's pretty good reasoning. Maybe we should apply that reasoning in our state. So what's the future? I don't know. Okay. And if you know, would you let me know? Because I've got a lottery ticket I want to buy over the weekend and I'd like to know the future. Okay. That would be great. I think it's incumbent upon us to understand what the courts say as well about our policies, about the forms that we use in the industry, because quite frankly, the courts are going to enforce through their eyes what we do. and what is done by and for our insureds. So we may all have opinions on it, but what the court says is really what matters, okay? So we're going to look at, as I said, 3 court cases. We're going to look at them with some speed, if you will, or alacrity, since I like the word alacrity and I don't get to use it very often. And I call this a review of the certificate of insurance, our venerable friend and our unrelenting enemy. So suffice it to say, we'll just leave it at that, okay? But these can be trying times, if you will, when it comes to certificates of insurance. So let's move forward. You doubtless know, I'm pretty sure you've heard about this one because those of us in the industry who deal with certificates of insurance have off and on been talking about T-Mobile USA versus Selective Insurance ever since the decision was filed on October 10th, 2019 in the Supreme Court of the state of Washington. And this was one of those questions that was somewhat concerning to a number of people in the industry, okay? And here's what the court said in their filing. And I'm going to, I may as well warn you right now. I'm going to read some case law language to you. My apologies. I'm better off reading it, though, than I am paraphrasing it. And here's what the court said at that case. This is addressing the Supreme Court of the state of Washington is addressing what the Ninth Circuit Court of Appeals asked them to determine. They've asked whether in Washington an insurance company is bound by its agent's written representation made in a certificate of insurance that a particular corporation is an additional insured under a given policy. The question arises in a specific court that the Ninth Circuit had already ruled that the agent acted with apparent authority, in other words, authority that was granted to them apparently by their relationship with the insurer they were dealing with, and that the agent's representation turned out to be inconsistent with policy language. Oh my goodness, there's a shock, right? And the certificate included additional text broadly disclaiming the certificate's ability to amend, extend, or alter the coverage afforded by the policy. Okay? And in this case, the question presented to the court in Washington was, under Washington law, is an insurer bound by representations made by its authorized agent in a certificate of insurance with respect to a party status as an additional insured under a policy issued by the insurer, even when the certificate itself includes language saying it doesn't have the authority to expand coverage, right? That language that we've seen on file after file after file when we've looked at this, okay? Now, and the court said, under the state's law, the answer is yes. An insurance company is bound by the representation of its agent in those circumstances. Otherwise, an insurance company's representations would be meaningless and it could mislead without consequence. Fascinating thought. Now, I'm going to run through this real quickly again with you just so that we all know who the players are and how it worked and how this decision was achieved. But essentially, there's 2 T-Mobiles in this case, T-Mobile Northeast, known as T-Mobile NE, and T-Mobile USA, right? They're separate, distinct entities. That's what the court acknowledges. That is what everyone knows, right? And there was a contract between T-Mobile Northeast and a contractor, required the contractor to procure a CGL, okay, to annually provide T-Mobile Northeast with certificates of insurance evidencing the policy's coverage, and to name T-Mobile Northeast as an additional insured under the policy, okay? That's all. Those are all facts in this court case. Those are all facts that occurred, okay? Now, what else do we know? Well, we know that the contractor obtained the required policy from Selective Insurance Company of America. The policy was and remains a claims-made policy, but that in this situation, that really is extraneous at best. Really doesn't mean anything. It's just a note that the court made when they looked at this as well, okay? It provided that a third party would automatically become an additional insured under the policy if the contractor and the third party entered into their own contract, and that contract required the contractor to add the third party to its insurance policy as an AI, an additional insured. No surprise here. We know how that works. We've got, although it's not a technically correct term, we have what are called blanket additional insureds, right? And that if one already has a contract, then they're going to be considered an additional insured under the policy. So everyone goes along. We're all happy. Hallelujah. We hold hands, sing kumbaya, and we move forward. All right. Well, here's what happens, okay? They got the policy. This was for a cell tower that was being put on a New York City rooftop, okay? T-Mobile USA did not have a contract with the contractor, nor did it automatically become an AI under the policy. Nonetheless, over 7 years, Selective's agent issued a series of certificates, including the one underlying this dispute, to T-Mobile USA, even though they weren't a party to the contract, okay? Now, as all this transpired, you know what happens. As we say in the trade, right? Nothing matters until there's a loss. And then what matters? Everything matters. Well, here's what happened here. We had a loss. And then when the loss occurred, we didn't have the proper language. We didn't have the proper coverage in place. And so what was asked, the court said, well, we've got a dilemma and we need an answer. Washington state law specifically says that a certificate of insurance does not trump policy language. Now, if you're an insurance agent, if you're an insurer, okay, this is no surprise to you. We've learned, we've expected to understand that. We've known that for a number of years. We realize that, quite frankly, in our perspective, what have I been teaching? What have many been teaching? What I continue to teach is that in the vast majority of states, a certificate of insurance does not trump policy language. However, it doesn't matter if you're the one affected by it, right? Then what matters is where you are, where's your insured, how are they affected? And this specific case in Washington says, well, we've got a couple of issues here. A COI does not trump policy language. However, in the state of Washington, there also is a rule that an insurer is bound by the representations of its authorized agent, which this particular agency was. They were a representative of Selective Insurance. They had in place an agency agreement with Selective Insurance. They issued the certificate of insurance then effectively on whose behalf? On behalf of the insured, but also on behalf of Selective Insurance. So the court said, okay, we've got a decision to make. Does a certificate of insurance trump policy language or not? When we look at the rule in the state of Washington that an insurer is bound by the representations of its authorized agent. Which is it? Here's the answer. Okay? An insurance company's agent who makes an authoritative representation binds the insurance company even when that specific representation is transmitted via a certificate of insurance and accompanied by general disclaimers. In other words, to answer the question that was presented to the Washington State Court, a certificate in this situation does essentially trump policy language, and therefore coverage will apply. Now, the T-Mobile case is not necessarily an outlier, however. Pardon me, I've got the sniffles today, evidently. Happens every time I talk about certificates of insurance. It just chokes me up. It gets me every time. What can I say? So over the years, there have been other court cases, and we're going to look at those in a minute as we go forward. I'm going to look at two in particular, probably less publicized than the T-Mobile case, but also no less important than the T-Mobile case because of how they are viewed. But before we go there, I want to share with you the dissent of one of the jurists, if you will, one of the judges in the T-Mobile case. And the dissent is the dissent that probably I would expect and probably you would expect to hear. And it's actually about a 4-page dissent. No, I'm not going to read all of it to you. Just chill. Okay, don't get wacky about this. But listen to this. And in the dissent, the Judge Madsen says, generally, a certificate of insurance cannot create a contractual relationship between an insurer and an alleged additional insured if the policy itself does not provide for such a relationship, which is what we've always thought. Moreover, the certificates at issue here contain standard disclaimer language conferring no rights upon the certificate holder or amending, extending, or altering coverage. In other words, as the judge said in the dissent, because the insurance policy did not recognize T-Mobile USA as an additional insured, the certificates of insurance have no effect on T-Mobile USA's coverage. That is what you and I probably would have expected, but that was the dissent. In other words, this opinion was a minority opinion. Now, the one thing I like about this from that standpoint is in this dissent, the jurist, Judge Madsen, still says that the preceding language I just read to you, this is a prevailing view of the courts that have considered this issue. The majority view is that where a certificate of insurance expressly indicates it is not to alter the coverage of an underlying certificate of insurance, okay? It is not to alter the coverage on the underlying policy. The requisite intent is not shown and the certificate will not affect the change in the policy. And then he cites a couple of sources. So, and he says, again, this is majority view. Courts have generally held that certs do not control over policies for 2 specific reasons. Certificates are informational only and show evidence that insurance exists, and disclaimers contained in most certificates plainly state the terms of the insurance policy control. Well, sadly, the judge in Washington lost on the dissent, and the other majority opinion now holds supreme, if you will, pardon the pun, pretty much intended, in the state of Washington. Now, so what else does this tell us? Well, it tells us again that for those of you that like black and white answers, right? The right and the wrong. Casey, is it this or is it this? Just tell me. I can't tell you that, right? Why? Because it's going to depend upon your jurisdiction. It's going to depend where your insured is working. It's going to depend where the litigation is taken. All these things are dependencies, contingencies, if you will, on our policies. So let's take a look at a couple of others. And I'm going to give credit where credit is due at the end of the presentation when I go ahead and give my thanks to a certain couple of folks that helped me put this together, okay, from the standpoint of gathering this information. And I just want you to know, I've read this decision that we're looking at here, Blackburn, Nichols, and Smith against National Farmers Union Property and Casualty Company a number of times. And still, it gets a little convoluted because of the players, what happened, how stuff went on, etc. There's an appeal, there's a cross appeal, there's an appeal of the appeal, etc. And it gets a little funky, okay? But I'm going to try and summarize it for you in a manner that makes sense to you, hopefully makes sense to me, because that would be helpful since I'm trying to explain it. And go down that road about what we're looking at here, okay? So here's the case. This is an appeal from a judgment in an insurance coverage dispute. Oh, there you go, okay? October 7, 1985, auto accident. The court ruled that Scott Smith, doing business as Smitty's Lawn Service, was insured by Aetna Casualty and Surety Company. and that Aetna was entitled to be indemnified against Rude Insurance, okay? That's the agent involved. The accident involved a collision between Smith, a vehicle owned by Smith and driven by one of Smith's employees, Mr. Dagner, and a vehicle driven by Mr. Amstutz and occupied by Mr. Amstutz's mother, Alta Amstutz. Okay? And then they talk about who had a policy, who didn't have a policy, etc. Dagner had a personal auto policy, a National Farmers Union. Smith said he had coverage with Aetna. Both carriers denied coverage. That's the bottom line, okay? Dagner and Smith then filed against the agency, alleging it had breached its promise to procure a policy for Smith with Aetna. Rude then filed a third-party complaint against the insurance broker, alleging that they had negligently failed to provide coverage for Smith. Rude then settles all claims to Amstutz, another Am. I told you, this stuff gets whack, okay? Let's look at the rest of the story and see if it will provide us with a bit of clarity when we look at this specific case. And again, this is from our good friends in the state of North Dakota. Okay? And here's what happened. On April 16, 1985, Smith asked Rude's agent to provide him with a liability insurance for his lawn spraying business. Okay? Mr. Smith asked, we're going to call the insurance agent Corinne because her last name is a little harder to pronounce, to provide him with liability insurance coverage for his commercial lawn spraying business and for his vehicles. Okay. Smith, the purchaser here, the customer, gave Corinne $200 as a down payment for the insurance premium. Corinne then gave Smith an oral insurance binder and sent an application for coverage to Aetna. Okay? So far, so good, etc. All right. Well, what else happened? Well, on April 26, 85, before Aetna had any contact with Corinne about the application, Corinne gave him a certificate of insurance showing that he had coverage until April 16, 1986. Okay? Would make sense, right? Certificate issued for a year over the course of when that snapshot was taken. On the certificate, under policy number, she marked pending, okay? Gave a copy of the certificate to Mr. Smith, retained other copies of the cert in his file, okay? Nothing was ever transmitted to Aetna. A few days later, Aetna calls and says, hey, got a little problem here, Corinne. We don't like this risk, okay? The underwriter, right? Called Corinne and said Aetna would not provide CGL coverage for Smith because of dangerous chemicals used in the business, in the lawn spraying business, but that's a different issue, right? But that as a courtesy to Smith, Aetna would provide temporary auto insurance policy for Smith until the agency and Corinne could place coverage with another. But that this temporary coverage was not to extend beyond June 1, 85. Now, these are facts in the case that people are not disputing. They said, yep, this is what happened, okay? So what does Corinne do at the agency, at the Rude agency? She then goes ahead and prepares another application asking another organization, BNS, right, the party to this claim, right, Blackburn, Nichols, and Smith, to go ahead and issue another policy. Well, Smith notifies Corinne and Rude of an accident on 10/7/85, well after the June 1, 85 expiration, right, of that oral binder, right? Well, you know what happens now. Well, then Corinne and Rude, the agency, asked him for a copy of the insurance policy showing that Smith had coverage. Oh, what a shock. They say no, they had never agreed to provide coverage. Rude then, Corinne, then returns the $200 to Mr. Smith and says, well, Mr. Smith, don't know what to tell you, but, you got no coverage. It's a bad day. And Dodge City or whatever, but you're not going to have any coverage on it here. Aetna denies coverage based upon the expiration of the oral binder, but the cert was issued showing coverage until 86. Liability in this case is predicated upon the cert issued by RUID, not the oral binder. That's what these folks come down to, okay? So let me read you a little bit of what went on in the court case. Aetna asserts that the trial court erred in concluding that Mr. Smith had liability under Aetna on the date of the accident. Aetna claims that Smith was not insured by Aetna at the time because the oral temporary binder had expired. And the court says, and you know this is not a good note for Aetna, right? It appears that Aetna has misconstrued the basis for his liability in this case, which is predicated upon the certificate of insurance issued to Smith by RUID, not upon the oral binder of insurance. Oh, this could not end well. I get the feeling, don't you? And then they go on and says, well, you know, it had the standard language, right? That we see on certs all the time. Certify the policies of insurance listed below have been issued to the insured named above are enforced at this time. Issued for information only and that it does not amend, extend, or alter the coverage. But then the court said, look, this case must be viewed through the insured Smith's eyes, who left Corinne/RUID's premises with a certificate in his hand indicating he was covered for almost a year, and he felt that he did, in fact, have insurance coverage for RUID. Not pretty, okay? The agency then, in the decision of the courts, the agency, RUID, is required to indemnify Aetna, right? And then the court just goes ahead and tells us, look, indemnification is a remedy when one party is exposed to liability because of the actions of another. And where did RUID fail? The agency fail in this regard? Well, they failed to keep Aetna informed as required by their contract with Aetna, and they acted negligently in the handling of Smith's insurance application. The final reasoning of the court is this. And the court said, one of the tests of an agent's powers is his ostensible or apparent authority, right? An agent or agency has the power to bind the principal. An agent can make contracts, receive payments, and can do all of the other items specified in the agency agreement. RUID, the agency, aka Corinne, if you will, was invested with all these powers and under these powers accepted Smith's application and bound coverage through Aetna until the coverage was legally canceled. Remember, under the law of agency, and this is one of those things, right, we probably all learned when we first got licensed back in the day when we took our licensing classes, right, that under the law of agency, we have express authority, we have implied authority, and we have apparent authority, right? Express is that which is given us directly in the contracts that we sign with the carriers we represent. Implied is the stuff that is in that contract that we need to do to go ahead and do our jobs. That's kind of like implied authority. And then apparent authority is the appearance of power on behalf of the insurer through the actions of the agency. And that's what the court said is, hey, look, your apparent authority here, we're going to look at this and say it overwhelms, it overrides, it overwrites the binder, etc. And that your failure, Mr. RUID agency, to keep Aetna informed constituted a material breach of the agency duties. And therefore, they bound for that party. Another fine case that you've gotten to say. Yes, Patrick.
We had a comment that we could, I think, construe as a question here. One of the participants says, with only one minimum payment issued for coverage.
With only one what?
With only one minimum payment issued for coverage. So yeah. With the court made this ruling and all of this, they paid, what, $200 cash at the beginning?
Yeah, you think I'm making that up, don't you? And it's buried in here. And this is only a 6-page decision, which makes it pretty friendly reading. And let's see, where is it? Let's see if I can find it here. If I can find it rapidly. But yes, the court said, yeah, he only made the $200 payment, but here it is. There is no finding that Smith acted negligently. Smith, the guy who bought the insurance, right, gave him the $200. There is no finding that Smith acted negligently or without good faith in relying on the certificate for his belief that he had insurance. He paid $200 for that coverage, and in reliance on the certificate's statement of coverage, he did not attempt to secure other coverage. Therefore, we conclude that when Ruud issued the certificate of insurance to Smith, Smith acquired liability insurance coverage through Aetna as provided by the certificate. Absent cancellation of the coverage by Aetna in accordance with the terms of its policy, Aetna was liable for the coverage indicated by the certificate. Yeah, you don't expect me to comment further because I'm pretty sure that the Supreme Court of the state of North Dakota and I would have a pretty broad disagreement about how they interpreted that language. Yeah, but that's what they said. Yeah. Isn't that an amazing thing? Now, that's $200.85 as opposed to $200 and $22. But still, I know. That's what they said. I know. If you got more to go, let me know. Otherwise, I'm moving on to Midland Enterprises and St. Paul Fire Marine Insurance.
Thank you.
Okay. All right. No, thanks for that. I know. I'm glad someone asked about that because that was my same impression when I first read that. And then I had to grab a second glass of wine and read it again just to make sure I got it right because I thought, whoa, this sounds weird. Yeah, true. All right. Our last one that we're going to look at, and I'll try and make this brief. This is again this is only a 5-page court of appeal out of the state of Ohio, okay? And there was a 1992 sinking of a historic dredge boat that precipitated this case, right? A jury found that the insurer, St. Paul Fire Marine Insurance, was obligated to provide liability coverage to the insured Midland Enterprises, Inc., the company that towed the dredge, and had been sued by the dredge's owner for allegedly causing the dredge to sink. We believe the jury was correct, and we affirm. Okay, so that's kind of the introduction to this whole story. Now, the facts of this case are, again, this is, it's one of those weird things, right? Midland Enterprises provides towing services on the inland river systems in the U.S. as part of what is called the Cincinnati Tall Stacks 1992 event. The Greater Cincinnati Tall Stacks Commission asked Midland to volunteer its services to tow a historic dredge boat named the St. Genevieve to the Cincinnati area. Volunteer. So I look at this, and this falls under the heading of no good deed goes unpunished, right? That's how I look at this one. Midland said it would do the towing on the condition that the commission provided it with insurance coverage in case anything happened while the dredge was in transit. The commission referred Midland to an insurance broker, Alexander & Alexander of Ohio. Okay, and then what do? We go ahead and we have some coverage, and here's what happened, okay? They asked for towers liability, all right? St. Paul issued a binder of insurance showing $250,000 of coverage, okay? On September 25, a certificate of insurance was issued by Alexander & Alexander to Midland showing $1 million per occurrence for protection in indemnity coverage. Okay, well, good enough there so far. And here's what it says, and it has some additional insured language, et cetera, right? As respects to towing the St. Genevieve dredge from Grafton to New York, blah, blah, blah. It's hereby understood, boom, and everyone's happy. And again, no harm, no foul, because we don't have a loss. Until the next slide, when we see that it sank while being towed to the event. St. Paul paid $250,000 to the owners of Genevieve as per what they thought they had coverage-wise, right? Listed the value of the Genevieve at $250,000. Midland sued for more money because they were involved in the extent of this loss to another $147,000 and change, right? And here's what came down in the telling of the rest of this story. Midland sued both St. Paul and A&A, but A&A settled. This is not a part of the case. The case went to trial. Jury decided that St. Paul owed, at the very least, a defense to Midland. St. Paul then said, no, we're going to appeal, right? And this came down to, very simply, the question of what wins, okay? But here's what the court said in this one. And I know we're going through this rapidly, but I'm doing this just to give us a flavor of what can happen when we end up in court, okay? And how things can go in ways that we don't necessarily expect them to go. Here's what the court said. The basic point of dispute is whether St. Paul had agreed to provide towers liability coverage for the sinking of the St. Genevieve. According to St. Paul, the binder of insurance showed that coverage was not intended. According to Midland, the certificate of insurance showed that there was coverage. And then the court then said, look, this case is unique because unlike most insurance coverage disputes, the terms of the formal policy are not at issue. In fact, there was a policy that was issued, but it was issued after the actual loss. So the court said, look, we're not even going to look at that policy because that policy has nothing to do with this dispute, okay? It's not appropriate to look at the terms of a policy that was not issued when the alleged triggering event for the coverage, the sinking of the ship, occurred. Thus, the parties correctly focused on the binder and the certificate, both of which were issued before the St. Genevieve sank. And the arguments then were this, that legally a binder serves a different purpose than a certificate of insurance. I think we would agree with that, would we not? Right? A binder is a temporary substitute, a temporary policy of insurance that is effective until the issuance of a formal policy. A certificate is not a policy itself, but it serves as evidence of coverage. In cases such as this, where the binder and certificate present competing suggestions as to whether certain coverage is provided, and where the formal insurance policy is not in effect when the triggering event for the coverage occurred, we cannot look at either the binder or the certificate in isolation. Pretty significant language. We can't look at these in isolation. So what can we do? Well, contrary to the argument provided to the court, okay, to the court from St. Paul, the certificate did not merely serve to certify coverage provided by the binder, okay? We have to look at both of these to determine in an objective viewpoint whether coverage applied or not, okay? And they said, looking at both the binder and the certificate, we conclude that the competing interpretations offered by St. Paul and Midland, these are both reasonable. In light of competing interpretations, we conclude that the trial court didn't do anything wrong in denying a summary judgment for Midland, okay? And that this appeal is not well taken. So, a lot of information in a short period of time, and we'd want to read the totality of these losses to have a complete understanding of what goes on. Here's what I think we find whenever we look at certificates of insurance: the good, the bad, and the ugly. Is that in the vast majority of cases, we don't have issues, right? Vast majority. Why do we talk about these? Because they're outliers, because they are potentially, if you're the one involved, it's not an outlier to you, it's important to you, okay? Now, a reminder is that whenever we get involved in court cases, the one thing that we have to remember as outsiders looking in on this loss or these various losses is that the set of facts that are applicable with one loss may not very neatly transfer over to another loss. There is no one-size-fits-all decision per se, right? We've looked at 3 different states, Washington, North Dakota, and Ohio, with the recognition that, as indicated in the dissent from Washington, that the majority of states say, look, a certificate is more or less a snapshot in time and nothing more to worry about it, okay? On the other hand, if we were to look at some claims coming out of certificates of insurance, here are just 3, and these 3 are indicated in some paperwork that is provided by Swiss Re, which is the Big I national program for agency E&O, where additional insured coverage is provided under a blanket AI endorsement, but there was no contractual requirement was in place for the AI issuance, and that was a $445,000 E&O loss. And failure to order an additional insured endorsement after issuance of a certificate of insurance was an $180,000 loss. And then the third one, which I call the big kahuna of certificate of insurance losses, where an agency issued 4,000 certificates of 4,000, right? You read that right. That's not a typo. For an employee leasing company showing workers' comp in place that was never issued. And the result was, a $10 million loss. So this all comes back, and if you ask me, begs the question of what are we to do? How to protect ourselves? Well, as we know in life, we cannot make ourselves or others bulletproof per se. Pardon the expression, but I think it drives home the point. So what can we do? Well, we can have good procedures in place regarding, at the agency and brokerage level, regarding the issuance of certificates of insurance, about who is allowed to issue certificates of insurance, who is not, what we can put on them, what we cannot put on them, etc. Okay, number 1. Number 2, we want to make certain that the certificates of insurance that we're using are the most current editions, most of which are the 2016 editions of the Accord certificates of insurance. We remind ourselves that as agents et al., that we should never modify the language on the certificate of insurance. Okay? We don't want to, that's not our step. That's not our bailiwick. We shouldn't be working in that regard. We don't want to utilize non-accord forms without prior approval from the insurer in question. Sometimes when we're dealing with insureds will have relationships with other organizations, and the other organization wants that insured's agency to use a non-accord certificate of insurance, to which we say, no, you're not to do that unless you receive written approval from the insurer to, yes, go ahead and issue the non-accord COI. But absent approval, I don't want to have that going on, okay? Now, one of you just asked about, are the slides going to be provided by email afterwards? I think that's a Patrick or a George question. So I don't know the answer to that. Oh, you stumped me. There you go. Not hard to do. Okay.
The answer is yes.
Okay. Well, look at that. That voice from the netherworld just came in and gave us a positive answer.
As I actually read the question completely, the slides will be available when the recording is available online. So give us a couple of days and you'll have access to it.
Look at that. The word has come down. I like that. I was pretty sure the answer, but I didn't know how to work it. So there. Finally, right? Because, look, we know certificates are not, they're not to be just used willy-nilly, if you will, right? There are issues of complexity, and we want to make certain that the people that are issuing them in our agency organizations are qualified and well-trained, and that they understand how an issuance of a certificate of insurance could have or adverse effects. And recognizing that, we then are dealing with the right people. So how else can we protect ourselves, right? Well, we can also protect ourselves that when we review contracts for the insured, and this is always a question, right? Should I review contracts for my insured or should I not review contracts for my insured? Well, I got news for you. I'm not going to give you a black and white answer there either, right? It's one of those things that where we can give you a solid it depends, right? And what it depends upon is what is your relationship with the insured? What are you reviewing for them? Are you reviewing the totality of the contract? Are you reviewing just the insurance language in the contract? And if you are reviewing contracts, and I understand that many of us do, and I don't think it's necessarily a bad thing, as long as we have in place an appropriate disclaimer regarding the extent of what our review was in regards to, which is a poorly constructed sentence, but I think you understand where I'm going with this. We want to make certain that when we review contracts, that our insureds do not think we're taking the place of their attorney or putting ourselves in the shoes of being an attorney or their legal representative. Unless we have the initials JD after our names, we should not pursue that. If you have the initials JD after your names and you want to pursue it, be my guest. But most of us do not in the world of the insurance agency business. And so in that regard, if I'm going to be reviewing contracts for an insured, you can bet your sweet bippy, as they used to say years ago, whatever a bippy is, you can bet your sweet bippy that I will have an appropriate disclaimer regarding the extent of what I reviewed contractually for my insured. Okay? Make certain you're aware of what additions of AI endorsements are in use by your insurer for that specific insured. Now, this can be problematic because let's say if you're dealing with an agency carrier and you know exactly what they're doing and you've been dealing with them for a number of years and you're looking at their additional insured language and you know what they're issuing all the time, you're going to have a good handle on it. But let's say you've got an account where you've got part of it with an excess and surplus lines broker or a wholesaler or an MGA, and you've got part of it with a standard carrier. You may not know what's coming out, and we've got to know what's coming out when we start looking at additional insured endorsements. So be aware of what you're promising per se when you're going ahead and trying to illustrate the point to your insurers by issuing a certificate of insurance upon which they're going to rely, upon which, as we've seen, others may rely. And when others rely on it, and again, as we say, it's all fun and games until the loss occurs. And then after that point, we don't know what's going to happen, right? That's where the proverbial rubber meets the road. And then even though I know most insurers don't want you to send them to them, you know what I'm going to do? I'm going to send them to them, okay? Now, insurers don't primarily want us to send certificates of insurance because they don't want to know what the heck you're doing, okay? But on the other hand, if you're a representative, if you're an agency relationship with the insurer, don't you think they should know what you're doing on their behalf? So in my opinion, and the opinion of a number of others that teach certificates, classes, etc., I send the certs to the insurers in questions. Maybe I bundle them up once a week and send them home. I don't care if they want them or not. You know what? They have a shredder on their end that they can use. But I want them to know what I'm doing on their behalf. Why? Because look at what the court in Washington said. You represent the carrier. You now have modified the language that the carrier has. Not necessarily what was expected. All right. I want to thank a great resource in Crystal, who currently is working with Great American Insurance. She is an attorney, okay, and provided me with some of the case law research that I didn't have great access to that she did. The E&O risk management